I'm Ashley Lambert of the Ashley Lambert Law Office. I'm here today to talk to you about family law, specifically division of property in the state of Arkansas. So, the state of Arkansas does not have a 50-50 percentage split when dividing property during the divorce proceeding. So, if you're thinking, well, I'm going to get half of everything anyway, I wouldn't count on it. But there's always an exception to the exception. So if the division of property falls that way, it just happened to fall that way. But the state of Arkansas does not have a 50-50 split. What Arkansas does have is what's called equitable division of property. What is equitable division of property? Equitable division of property is basically what's considered to be fair. The judge will try to get it as close as fair as possible. Now, notice I did say judge. Who's going to decide what's fair when dividing up your property? Considering all the years you've been married, all the blood, sweat, and tears, hopefully not any blood, but that you've put into your marriage, the judge is going to decide what is fair. That's why it is important to try to come to an amicable decision on who's going to get what. Divorce does not have to be messy. So if you and your soon-to-be ex-spouse can come together and decide on the property, the marital assets, it will make your life much easier. Now, when making this decision, it's best that you do get an attorney to do this. Why? Well, because if the judge if he or she were going to decide what's fair, they will consider a few factors to determine what will be an equitable decision or split of property. One of the factors will be employment of each partner. Or soon to be ex-partners. The education of each party, the ages of each party. Why do they consider the ages? Well, because they want to know what the earning ability or potential is when splitting up assets. Said education and, even a disability. These are just a few of the factors that the judge will consider when making an equitable split of property. That's why, again, it's important to hire an attorney to help. Both of you will have to hire an attorney to make this decision because, of course, you can't have the same attorney. So what about, we're talking about marital assets. So what about gifts and inheritances? Well, typically a gift and or inheritance is sole and separate property. It is not a marital asset. A marital asset is property or money acquired during the marriage. But in most cases, an inheritance or a gift is not. It is sole and separate property. However, as I said before, there's always an exception to the exception. Sometimes sole and separate property can be converted into marital property. That's going to be something for another time. I want to keep this video really brief. So, as I stated, the state of Arkansas does not have a 50-50 split. They have what's called equitable division of property. What is fair? And when I say equitable division of property, equitable division of marital property. Sole and separate property that you acquired prior to the marriage that have not been converted, or property that is an inheritance or gift. That's not configured into the equitable division of property. Well, that's a wrap for Let's Talk Legal. This is attorney Ashley Lambert. Until next time, be blessed and be safe.